I think that they are reasonably familiar with what the concepts are, although they are not always sensitive to the implications. When we talk about the First Amendment as prohibition on the establishment of religion, it is very hard for them to accept the fact that there were established churches on the state level and that they would continue in existence until 1833. Why is it that there should be an established religion on the state level but not a national established church? The Church of England was something that they wanted to avoid, whereas they accepted the fact that the citizens of Massachusetts could have a state established church if they wanted. What does it mean to have the free exercise of religion? The free exercise of religion, as defined in the 18th century by Americans, by the founders, was the free exercise of Christian religion. It would be a Protestant religion, it could be evangelical, it could be Catholic. Agnostics were frowned upon, atheists were not accepted, and non-Christian faiths were not accepted. So when you look at the establishment of religion and the free exercise clause, it is far more limited in the 18th century than it would be in the 21st century. Another thing is the right to bear arms. People take that literally and argue that the right of the people to keep and bear arms is something that's guaranteed in the Constitution, whereas there's a certain ambiguity over whether or not it is an individual right or whether it's a collective right, which is identified with the militia. Freedom of speech is another good example where people take it literally, which is to say I should be allowed to do whatever I want. I think there are several things going on here. One is, in the 18th century, freedom of speech was often identified with the rights of a Republican society. That is, it was a political right that would encourage the free expression of ideas having to do with your political responsibility. It has been transformed in the 20th century into flag burning, naked dancing in taverns as an expression of freedom of speech, which an 18th century person would never recognize. As for yelling fire in a crowded theater, there are restrictions, and the Supreme Court has recognized those restrictions, that is, you have certain social responsibilities and you do not have an absolute right. So all of these rights are conditional, and the question is, what is conditioned? The War on Terror, perfect example, because what our government tells us in the War on Terror is that we should be willing to accept restrictions on our individual rights, our rights to use telephones and things like that, our rights to access the court, to use habeas corpus, and people are basically starting to push back and saying, well, that's your assertion, but there has to be a justification for that.